Hey there, Greg Siskind here. I am solo this evening, and I thought I would spend the my time tonight talking about the California v. Mullen decision that came out of Massachusetts um, earlier this week. This is the H-1B $100,000 tax decision. There was also the big Dorcas decision in Rhode Island that dealt on Friday with the benefits pause of USCIS, and I think I'm still working on that. I think I'm going to do another live stream talking about that case separately. Although I may mention a few things about the that case at the end, and there's some related elements of both of these cases. For example, they're both coming out of the First Circuit, one in Rhode Island and next door, one in Massachusetts. And we might talk about why that circuit is one that is a hotspot for litigation. And I'll talk about how the California v. Mullins decision connects with the lawsuit that I'm co-counsel in, the Global Nurse Force case in the Northern District of California. So I've designed some slides, and I've already posted the slides yesterday, but I will use them again today because I think that they kind of help to illustrate what I'm going to be talking about. So as this case was filed to challenge the policy, the proclamation from September, where the president issued a ban on the entry of people on an H-1B visa and then provided a national interest exception if they paid a $100,000 tax. And they called it a fee, but it's you'll see why in a minute that it's important that we keep calling it a tax. And that was and that policy, a lot of you may remember when it was issued, the thought was that it was going to cover everybody. Then the administration backtracked a bit after it was already after a couple of days and said it was only going to apply to people who were filing new applications after the proclamation went into effect. And then and they haven't made very few changes since. They also have not granted any national interest exceptions other than to, at least as of February, there were about 85 people that paid the $100,000 fee. They got exceptions. We don't know how many have been filed in the months since, but I know our firm, we had two of those, two cases filed. I don't know how of the total paid the fee. So let's talk about this. Was a pretty resounding win for the plaintiffs. And who were the plaintiffs? They were 20 states that have Democratic attorneys general. So the case is called California v. Mullen, and that's for Mark Wayne Mullen, the Secretary of Homeland Security. And even though it's called California v. Mullen, the case was actually filed in Boston in the district court for that city. So that being said, that there are let's see on here, the main thing that the case does is it issues something called a vacator. We'll get to that in a minute, but basically this is not a injunction. The states didn't ask for a preliminary injunction. They filed a motion for a summary judgment, which means that they asked for a ruling, a final ruling, and it took a little longer. It takes a little longer typically to do that, although as we're finding out in a lot of cases, preliminary injunctions can take months also for a judge to issue, and that includes the Global Nurse Force case. But they got something instead called a vacator as their remedy. And basically what the judge did is he set the entire policy aside, saying that this is illegal, period, for the government to be doing. And by setting it aside, it effectively has a nationwide benefit. So this is a timeline. Basically, the major things that happened. September 19th. That's when the proclamation was issued. Um, During months of September and October, we got some clarifications from the government. This lawsuit was filed in December. The motions for summary judgment were filed between February and April, and we just got a decision. So a lot of times people are like wondering, sort of like, what's the timeline for these cases? And this is this is not necessarily typical of every case, but it sometimes helps to see what we're talking about as far as how long it takes. So what did the proclamation do? I talked about it a minute ago, but basically, it had that $100,000 tax. They based it on Section 212F of the Immigration and Nationality Act. 212F is basically the president's go-to statute that says he can bar for almost any reason he feels like it, but not any reason, but a lot of reasons. He can bar the entry of individuals deemed to be that he deems to be contrary to the interests of the United States. And then 215A is another section that's basically an implementing section for that. But that's those are the powers that the president has to bar entry. He made it effective on September 21st. You may recall that was exactly, well, it was right after 10 days. Basically, if you get an H-1B in the lottery, you're allowed to file it for an October 1st start date, but you can enter the U.S. up to 10 days early. And what they did deliberately in the way that they timed this was to prevent anybody who won the lottery last year from entering. And then they got all the pushback and the bad media with people that were trying to get back into the country. And then all of a sudden they said, we didn't mean it. We're not going to punish people that won the lottery that were trying to come in and already had approved petitions. But you can tell by the way they timed it, where they had this go into effect 10 days beforehand, that was their intention. So when they said later on, this is classic gaslighting from the administration, that we just were making things up, and that's not what they meant. We know what they meant, because the date of September 21st was not an accident. They didn't just suddenly come up with the idea and decide to make that their date. They did that so that it would prevent people that won last year's lottery from entering. And they changed the way they interpreted it to apply prospectively only. So that being said, you can see with the little graph on the right what the fees would be before and after the policy. So it's a pretty extreme change, and that's why only it was 85 people as of February. Let's just assume there were maybe another 85 or 100 people that filed for that $100,000 fee. By the way, we'll let you know how we're obviously going to seek refunds for our clients that did pay that fee, and we'll see how how forthcoming the administration is. Of course, that depends on this policy being struck down, and this was a win, but there's still a long way to go. So who sued? It was 20 states, led by California. And why did they sue? What gave the states standing to sue? They argued that they have K through 12 teachers. They argued that they have public universities that they fund. They argue that they have public hospitals that get state funding. So they had they argue that that's what their interest, why they had an interest in this, makes sense. And they basically argue four different arguments. One is a constitutional argument, and that's count 4 that you see on the slide. And that was that the Congress has certain powers that are specifically for Congress, and the president can't just basically stomp on Congress's powers. And The reason, and the specific power that the judge is going to be talking about as we talk about this is the power to tax. Congress has a lot of you may know from studying your civics that the Congress has what's called the power of the purse. They have the power to decide on taxes and how money is going to be spent. The president doesn't get that authority. So when the president called something $100,000 fee, and the judge discusses this, the fee has to actually have some connection to the amount of work that's required. If it's way in excess of that, it's more likely a tax, and that's unconstitutional. The other three arguments were surrounding something called the APA, which stands for the Administrative Procedure Act, and that has to do with how policies are rolled out to the public. And because they rolled this out as a fee, even if it wasn't a tax, that means that uh, you have to follow the Administrative Procedures Act. And they said first off there was no notice and comment. This was just rolled out without any warning. Two, that it can't be in excess of of statutory authority. Some of you may have heard of a case called Loper Bright. It was decided by the Supreme Court last year, and Loper Bright says that exactly that. That's the agencies they can't just basically make things up. They have to make up interpretations that are not explicitly authorized by statute, and that was indeed one of the issues here. And the last is one that they could lose on just about every one of their policies if the judge decides to hear Administrative Procedure Act arguments, which is that the policy is arbitrary, meaning it's kind of random, but capricious, meaning it is designed to be punitive, and it's not it's designed to punish, and not to achieve a legitimate policy. So those are the four major arguments that the states were making, the state attorneys general were making. So the next thing that you have to meet when you're filing litigation is you have to show that you have standing. And that is that the judge said that was satisfied because the states were able to show the harm to the schools, the universities, the hospitals, and that the harms that were being suffered could be connected to the policy and could be fixed if the litigation was successful. And you have to basically be able to show whatever relief the judge is going to provide would actually address the harm, which I think that's a fairly straightforward argument, and that they also the government actually didn't raise any objections to standing, so that argument stood without a problem. It's a loser. It's usually a loser for the government to try and make that argument on standing when you have these cases where you have all these attorneys general, and that's largely because they are the attorney general of a state. Each state has a fairly large legal team that is vetting these issues, and that's an issue they're not going to lose on, because they're not going to bother filing these cases if they haven't thoroughly basically documented that particular issue. The other question was the question of consular non-reviewability, and this is a principle that has been upheld by the Supreme Court, but basically it bars the courts from essentially looking at decisions by consular officers and reversing those decisions that are discretionary decisions. The judge shot that argument down pretty easily, saying that this had nothing to do with the denial of individual visas. This had to do with a policy, the policy itself, the broad policy, and there are cases that allow for judges to review that. So gets down to this question about whether it's a penalty or a tax. Um, if it's a penalty, that's treated differently than a tax. A tax, of course, is as I said, only Congress has the power to um, issue a tax. And you may remember the tariffs decision that came down a couple of months ago against the president, where they argued that that was for the same reasons that that was a tax, and that and that Congress had to authorize it. Um, so for it to be a penalty where the president does get some more discretion, you have to show that it's punishment for something, for some kind of unlawful act. A tax is just a required payment that doesn't have a legal consequence beyond the payment itself. It's just a payment. Um, and the judge said that it looked a lot more like the Sebelius case from 2012 than the Drexel case from 1922, meaning it looked a lot more like a tax than a penalty. The government was arguing that that it was in fact a penalty, but it was, and they made some arguments saying, for example, that if it was a tax, it would be collected by the IRS, not Homeland Security. But the judge said that there's nothing that requires the IRS to be the ones that actually collect a tax. They also argued that because so few people paid the tax and revenue fell, that it's not actually a tax because they're collecting less money than they did before the policy went into effect. And a tax, there are things called sin taxes, and they compared it to that. A sin tax is something where the government imposes a tax to try to influence behavior. It's not a penalty for anything that anybody did that was illegal, but the tax itself is aimed to influence behavior, and they compared it to cigarette taxes, where people can legally smoke, but the government puts taxes to try and maybe discourage them from doing so. And it looked more like that, where this $100,000 tax was being designed to discourage people from filing H-1B applications. And they also argued, the government, that it's a regulatory payment, but they didn't really have anything to support the fact that there was some kind of connection, the payment, to the actual provision of services. Okay, so the judge says this is on the ultra-vires part. Ultra-vires means it's beyond the law. That's something that the president's doing that's outside of the statute. And it's the principles were basically, as I've said, Congress is allowed to tax, that they have the power of the purse, that it's Congress has to actually make it clear that it's their intention to tax. There's nothing about $100,000 taxes in the Immigration and Nationality Act. So I'm not going to get into all of this, but essentially the judge said that that just because 212F allows for the president to bar entry, and if the president, for example, said we're going to bar the entry of all people on H-1Bs and didn't actually impose the tax to go along with it, it probably would have been a harder argument to win. But even there, the president can't just bar entries that effectively kill a program that Congress has authorized. And so there would probably still been pretty good arguments to make that the statutory scheme Congress set up for the H-1B program to operate, that the president can't just kill that whole program by barring the entry of people on H-1Bs, at least without some kind of emergency, like during COVID when they were barring the entries of people. That was that was a different situation. But here, they would have to show that it can't just be because the president doesn't like the H-1B program, when in fact Congress set that program up and intended it to be administered. Okay, so the This question came up about for the Administrative Procedures Act and agency actions. Is if this is something that comes from the president is not an agency, so can his actions are his actions even covered by the Administrative Procedure Act as opposed to something that was originated with the say USCIS or ICE or CBP? Um, and in this case, the answer is yes. That the president, if the president directs um, action of the agencies, in this case, this was CBP and USCIS and the State Department, he essentially is stepping into their shoes, and therefore his actions are reviewable under the Administrative Procedure Act, even if it's coming from an executive action. So that's an important thing because a lot of the things the president's been doing are by executive action or proclamation, and he can't get around saying that the Administrative Procedures Act has some coverage just because he's not an agency when the only way that these actions happen is by implementation by the agencies. So in this case, we had USCIS and CBP and Department of State all issued their own memos, putting it into effect. And then you had the FAQs and fee schedules and all kinds of things that were done by the agencies to implement what the president had ordered. So answer is yes, it's an agency action, even if it comes in the form of a proclamation. Um, Now we didn't have, we've just had some new proposed rules issued by the administration where they put it out for comment, and normally there's a 30 or 60 or 90-day period, and then the agencies have to go through a process of reviewing the regulations, and there's lots of laws that they have to go through. So in this case, we didn't have anything. We just had basically a Friday proclamation that was issued that was going to be going into effect on Sunday. Um, and that didn't follow any kind of notice and comment. And they argued that this was it was an emergency, but really it was just basically saying it was just designed to protect U.S. workers. Uh, I think under the most generous reads, there wasn't an emergency. Even if the president could make a defendable argument that it's good policy, it was to skip notice and comment. Um, he didn't. He would have to show a good cause for that, and he didn't offer anything. He didn't say that even that notice and comment would normally be required. So the judge here said there was no emergency, and they never even claimed there was an emergency because I don't think they believe that the Administrative Procedure Act even applied to them here. Um, as well, the judge said it was not a harmless error, and if they had gotten notice and comment, that they might have actually come to a different. I don't know. The judge said it might have well have changed the outcome. I think that wouldn't have changed the outcome because I think the administration was hell bent on doing this, regardless of whether the public was in favor of it or not. Um, then there is this question also with the Administrative Procedures Act about what the statute. I'm not talking about the taxing statute per se. I mean, the Constitution has to say, but just the statute itself, if it actually. So you have to remember, Congress is the one that issues laws, and the president basically administers laws Congress passes. So the president carries them out, which means the president has to abide by actual statutes that Congress puts out. Now, his agencies can put out regulations to make it clear to the public how it intends to carry out their statutory authority. But the president himself doesn't have the ability to basically just invent his own laws. So here the judge said, first off, that there's nothing in the Immigration Nationality Act that authorizes a $100,000 tax on H-1Bs. He also said that the Immigration Nationality Act only allows cost recovery adjudication fees. In other words, the administration is allowed to impose fees of their after public comment, by the way, but they're allowed to impose fees, but they have to be fees that are set at an amount that basically covers the cost of working on the application. So that's why when they issue their fee schedules, they actually put in the number of hours on average that it takes an examiner to adjudicate a particular kind of case, and they're allowed to set their fees based on that. So you can't just like say pick $100,000 fee unless you can say the examiner is going to be working on this thing for the entire year, and they were going to be putting in the amount of hours into it justify $100,000 being imposed on the applicant, and that's clearly not what happened here. And the government actually conceded that it wasn't a payment to cover costs. So that was not that was one they were going to have a problem with. So the judge ruled for the states on that particular issue. Arbitrary and capricious. So there's a case called State Farm, and the administration has to actually show that it went through quote unquote reasoned decision making. So all we got with the proclamation were a couple of paragraphs at the outset that basically said these are, the IT industry, and they only focused on the IT industry in those opening paragraphs, but they basically said that H-1Bs were driving down wages and taking jobs for U.S. workers, and the arguments that we usually hear, but not no data being cited, no studies, no nothing. It was just basically making those arguments without support. So the judge said here they didn't give an explanation for a major departure from the prior fee structure. They didn't basically look at the impact that the decision was going to have on people that were relying on the H-1B program and were under the assumption that it was going to be available. They didn't look at alternate policies, so they could have, for example, picked a lower amount. They could have looked at having carve-outs for certain occupations. That they could have looked at a lot of things, and they didn't do any of that. And then, like I just said, the attorneys general were smart, and we actually did this in the global nurse force case as well. Because the proclamation only focused on IT workers and STEM workers, we deliberately loaded up the global nurse force case with employers like nurses. That's what global nurse force is, and we also had a nephrology practice. We had university professors outside of STEM fields. We had lots of people that are not STEM, not IT, and the judge picked up on that, saying that they didn't give any rationale for why they imposed this across all occupations when the only when the only argument that they made was respect to IT workers. So they lost on that issue. So the judge has to decide on a remedy. Remedy means how is he going to, let's just say that they think that they agree with the plaintiff, and they have to figure out what they're going to do, what the judge is going to do. So they has to pick basically what's an appropriate way to address it. And in this case, the judge issued something called a vacator, and it's what it sounds like. The judge set aside or vacated a policy, and he did it on a nationwide basis. And basically, this is not an injunction, and it's not limited to the parties. It's basically telling the government, take this policy down, it's illegal. And when they take that policy down, it's not take this policy down for some people, where others just take this policy down, it's illegal. So there have been, and it's important that the judge did it this way, because the Supreme Court has made universal injunctions where they basically order the government to stop doing an action, that across the board, that's different than a vacator. It may lead to the same actual outcome, but it's not the same thing as a universal injunction, which would be very hard now under the Supreme Court the decisions, and that's a excuse me. That's a that you may recall that I think in the Trump v. Costa case, um, that what the Supreme Court was saying was that with these universal injunctions is that they were the courts that would I mean the courts could do essentially something on a universal basis, but they had to do it as a class action. Um, Class actions, it could have been done as a class action here, I suppose, and a universal injunction would be issued for the entire class. Um, but this was just a different way to pursue it. And they weren't pursuing an injunction; they were pursuing a motion for summary judgment. But in any case, we actually are pursuing class action certification in Global Nurse Force, the case that I'm working on. So it wouldn't really, that's a different way, that a different remedy that might be coming, and it might be important to have both a universal injunction via class action and a full vacator, um, if the government is indeed going to be pursuing appeals on these cases. So this is the issue, is that we already have the another case that's been decided at the district court level, which is where this case has been decided. And that is Chamber of Commerce versus the Department of Homeland Security. A lot of you probably remember that case from late last year. And that one, the judge ruled that this was a proper use of Section 212F, the entry ban, and that and the judge didn't get to really um, I don't think the judge really cared about whether it was called a tax, a penalty, a fee. In that case, Judge Howe basically said it was just a how the government what conditions the government wanted to attach to the entry ban. They could do that. Um, Now, one difference between that case and this case is that case was decided before the tariffs case was decided in the Supreme Court, which did say, which made it much harder for the president to impose things that are classified as a tax. And I'm not sure that the judge would have necessarily come to the same decision had that case already been decided. So that is a that's now that case was appealed to the D.C. Circuit Court of Appeals. The arguments have already been made, and we have been waiting for the D.C. Circuit Court to issue a decision. I am sure that the chamber lawyers took this decision and sent a notice to the circuit court to let them know that there's a relevant decision that's just been made on the subject. They can ignore it, but they oftentimes will look to the reasoning in the case, and it might be influential on how they make their decision. So but that's a different case, and we'll see where that one goes. But the judge did look at the question of whether the government made the argument that if a vacate that because there was this decision in the other case, that plaintiffs from the other case, including the chamber members and the the American Association of Universities, or who is another plaintiff in that case, that their members should not benefit from this decision because they had that negative decision. And the judge said, no, I'm setting aside the policy. I'm not leaving it in effect for certain members of associations that were plaintiffs in another case. So the government lost on that particular issue. So here are your three cases. California v. Mullen, that's the one I've just been talking about. Chamber of Commerce, I also just talked about that. So that one was one that upheld the fee, but it's right now on appeal. And then there's Global Nurse Force versus Trump, which is, like I said, that's the case that I'm working on. And that case is in California. The arguments were made, I believe, March 8th for the preliminary injunction. So we are now 3 months, April, May, June. Yeah, we're 3 months and to yep, since the arguments were made, almost precisely 3 months, and we're still waiting on the judge in that case to make a decision. Now, we already did notify the judge of California v. Mullen. Given how much media coverage there was nationally, I'm quite sure that the judge probably already knew about it before he got notified by us. But nevertheless, he has that. We also think the judge might have been waiting on the decision from the California v. Mullen case, or maybe the Chamber of Commerce v. DHS case in the appeals court before issuing his decision, just to kind of see what other judges had to say on this particular issue. We know that the judge was asking questions about the Chamber of Commerce District Court case when we had our arguments a couple months ago. So um, when the judge will issue a decision in Global Nurse Force, we don't know. But like I said, we are asking for something different than the states were. The states were asking for a vacator and a motion to dismiss. We are asking for a national injunction that will go along with that because we've asked for class certification, and we are following basically the way the Supreme Court wanted that to go. So we think that the administration is likely going to file an appeal, and they are going to ask the First Circuit, which is the appeals court that covers Massachusetts, that they're going to ask the First Circuit to issue what's called a stay. And basically, it says, um, while we are reviewing this case and until we issue a decision on whether the district court was right or not, we are going to leave the existing policy in place while we go about our business of considering the appeal. They could do that. That's happened many times on immigration policies where a district court rules one way and then the policy is stayed, particularly if the appeals court is it is a has different leanings as far as the than the district courts. And that one example of that is in the Ninth Circuit, where the Ninth Circuit used to be a very liberal court as far as, I mean, you hate to use terms like liberal and conservative, but it was generally leaning toward policies and decisions that people that are left of center would like. Um, the appeals court's gotten much more. They've had a lot of appointments by Republican presidents, and so it's much more conservative at that level. But some of the district courts in the Ninth Circuit have a very different leanings. So it's possible in the Ninth Circuit, it's more likely in the Ninth Circuit that you might get a stay on a decision that was issued by a district court judge. Not all, I mean, oftentimes that doesn't happen, but it could happen for those reasons. The First Circuit is generally not as much like that as the Ninth Circuit. So I think there's a better chance that the First Circuit is going to let this decision stand. And of course, this is going to send this probably up to the Supreme Court for review. The Supreme Court, though, I think is going to, they're going to look at probably this case and Global Nurse Force, which both were actually, interestingly, very careful to abide by previous Supreme Court decisions on whether they should stand or not. So, for example, using the vacator, um, that's not an injunction, and that's what was barred. So, by a previous Supreme Court case in Global Nurse Force, it was actually the questions came in. Why didn't the why shouldn't why don't these plaintiffs pursue class actions that they want universal injunctions? In Global Nurse Force, our case, we're asking for class certification. Um, there's the Loper Bright decision, which is cited as one of the reasons why why the district court judge is siding with the plaintiffs here, where the government is taking positions that are not authorized in the statute. That's essentially the Supreme Court and the new tariffs decision. Those are all things that are recent decisions by the Supreme Court that if they decide to side with the president here, they're essentially saying that their very recent decisions can be ignored, should have been ignored by a district court judge. So I think it puts the Supreme Court is kind of in a bind if they try to stop this from happening. They're essentially repudiating their own decisions. That's just my view of it, and I'm not sure that that's necessarily what the way it's going to be viewed by the Supreme Court, but that's what is being counted on. So we will see what is going to happen. I'm guessing we will probably have a decision in Global Nurse Force. I mean, we've been saying I've been telling you every week that it's like I'm expecting a decision any day now, and I think we're going to get that probably um, very soon. But that's that being said, the judge, um, I'm guessing he probably has a lot of his decision already written. He may have been waiting on these decisions to come in, so I'm guessing we're probably going to see a decision fairly soon on that particular case. So that's what I can tell you about this decision. I hope this was helpful. Um, there were a couple of questions. Let me see. I'm only answering questions tonight that have to do with this case. Um, so let's see. You think I'm going to stay on the H-1B case? Physician effect employers were about a sudden change again in the future. Possible that I think we'll know that in the next couple of days, though. First of all, the government hasn't issued any policy or anything yet. And that's kind of an interesting thing because the administration, the judge is going to be asking the Department of Justice lawyer to explain in the next couple of days why there's been no appeal filed yet. There's been nothing on the government's website saying that they are temporarily taking down the proclamation and and issuing H-1Bs again without the $100,000 fee. They haven't done anything, and they can get away with that for a couple of days, but the judge is going to have a problem with it if he set this policy aside and there's no indication that the judge's order is being taken up, especially if the government hasn't even bothered with an appeal. So we're going to probably see an appeal filed. I'm guessing they can't just I mean, of course, they can do it very quickly, but my guess is that we'll see that appeal. They have up to 60 days to file an appeal, but they don't have 60 days to ignore the court's order. So if they want a stay and for the First Circuit to basically allow the proclamation to continue while the appeal is going on, they're going to have to issue this appeal fairly quickly. Otherwise, the Judge Sorokin in Boston, is going to have a problem with the fact that they haven't done anything yet. But they haven't done anything yet. So I will tell you that we are advising our clients that they can act based on this decision, and they can attach this decision to applications, and they can try and get appointments at consulates. But My guess is that for the next couple of days, the administration, is basically going to tell officers at the different agencies that don't do anything on H-1Bs until we tell you to. So I don't think we're going to see anybody's going to see any quick actions based on this decision, but we are telling people to sort of be on standby because we may see an ability, especially if the judge, if they don't issue any if they don't file this appeal very soon, or the stay isn't actually issued, then we'll probably have a window where we can file. And you can't just say government can't just say if the First Circuit denies the stay, they can't just say, well, we're going to appeal to the Supreme Court. Um, First of all, they actually, if the Supreme Court, the Supreme Court can can stay it on their own, but you don't get stayed. They can't avoid actually doing what the judge ordered just on the hopes that the Supreme Court is going to do something. The Supreme Court would actually have to do something, and then the policy, and then it would stop. So there may be a window to get H-1Bs without the $100,000 fee, even if the government is deciding to appeal this up to the Supreme Court, at least for periods of time while that is happening. So you should be in touch with your immigration lawyer uh, and and see whether and see what your lawyer has to say. We have a question from Amipat. Same judge has to approve a stay, the same one that's directed down. No, this is the stay would be coming from the First Circuit Court of Appeals or the U.S. Supreme Court if they go higher than that, because the First Circuit is not giving them what they want. The judge has already issued the order. He won't be. He won't. Well, I mean, I take that back. You are correct that a judge can set aside his own order because he's afraid for some reason that it's going to have a big impact, and he'd like the appeal the government to have the opportunity to go higher. I think it's kind of a chicken move sometimes, but when a district court does that, um, that the judge is like, I issued this order. I believe in my reasoning, but I'm a little scared of the consequences, so I'm going to stay the order and give and let the policy that I've already said is illegal stay in force. So that's a that's the question is, could they appeal it without asking for a stay? Yes, they can, but the district court decision, then, if they don't get a stay, is going to be in effect until the appeals court makes the decision. Now keep in mind, this order goes is only in effect until September 21st, I believe, or September 19th of this year. So it's at the end of the summer. And we still don't know if the administration is even continuing the policy. So if they did that, what you just suggested, which is just to appeal without asking for a stay, could do that. But that would essentially run the clock out unless they issue a new proclamation extending the previous one. And that is also a question a lot of lawyers are talking about. Some law firms, including ours, have filed H-1B applications for start dates in October because the proclamation, we have H-1Bs that were approved in the lottery, and the start dates are in October, and that is after this proclamation expires. So, in theory, the administration may issue an extension, but as of now, if you're filing for an October or later start date, you're not covered by the $100,000 proclamation, lawsuit or no lawsuit. It's just a 1 year policy so far. I think a lot of people are assuming they're going to extend the policy, but they haven't. And they've had months to think about it. So we've had discussions, some of them on the air with Chuck Cook and others, about uh, what might be going on. And I am a believer in the idea that maybe the administration is uh, not planning on extending this policy because it didn't go as well as they thought it was going to go. They didn't have very many people pay the fee. They got a lot of flack in the not a lot of favorable press, and could very well be that they would like an exit ramp. And so maybe they'll appeal it and say that, look, we're going to go down fighting, but not to the point where they're going to they're going to try and further this policy beyond what it already has been. And so they were supposed to, by the way, be issuing a report to the president in March, I think. And as far as I know, that report was never actually given to the president regarding whether they should extend the policy or not. Okay, well, that's what I had to tell you guys about California v. Mullen. I may do another one of these on the 39 country benefits pause. That's a little more complicated. Judge in that case issued a 135-page decision last Friday. A lot of you may have known it. This is a Dorcas case. It's a very interesting read. I may try and put together a slide deck again on that and talk about it. I'm also co-counsel on several cases that are challenging the pause in different courts. I think we have cases in 3 different courts. There have so far been a few decisions on this issue, but the Dorcas is the only national one, the Dorcas case, and that's and we will we're assuming that the administration is going to fight on that case as well. So more information on that to come. I know that affects a lot of folks that are probably here tonight. But I just wanted tonight to focus on the one case, and hopefully I've given you guys some information that's helpful. And I will call it an end to the evening. I don't like doing these by myself. I like having somebody on where I can have a discussion with it, but didn't have volunteers tonight. So I will, you just got me, and I will probably, next week is the annual American Immigration Lawyers Association annual meeting. There are 4,000 immigration lawyers that go to this meeting. It's in California. You will probably have trouble getting hold of your immigration lawyer next week. That is why there's a decent chance that they will be there. Wednesday night, I will actually be at around this time doing a panel presentation at that conference. And I'm speaking also at a conference of international immigration lawyers from other countries that takes place a couple days before that, same location. So I will not be doing a live stream next week, and neither will any of my colleagues, because most of us, well, I don't know that that's true. There are a few of us that are not going from our firm, but most are going. I know I will see the Impact folks that you usually see me with on the earlier live streams will be there. Whether we do something together from California or not remains to be seen. But I did want to tell you why you won't be seeing me next week. So have a good one. Hopefully we'll get some more good decisions to talk about. I like when I get to tell you about good things instead of just bad policies. So more of this to come. Take it easy. Good night.